Mr. Brackett.
Good morning, Your Honors. May it please the Court, I'm Gary Brackett, representing the Appellant Board of Appeals of the City of Woburn, and with me is Heather Kingsbury. Members of the Court, this case presents, for the first time, a very important issue with respect to the scope of review by the Housing Appeals Committee from an approval with conditions by a local zoning board, and further the scope of review by the Superior Court pursuant to Chapter 38, Section 14 under the Administrative Procedure Act from that decision of the Housing Appeals Committee. At the beginning, there are two very important issues that are not in dispute. One is the fact that both the Housing Appeals Committee and the Superior Court confirmed that this project, as proposed at 640 units, was not consistent with local needs. It was too large for the site.
Let me ask you this, though. Why can't the court or the Housing Appeals Committee properly consider what the town did here to be a denial of any project in excess of 300 units?
Well, Your Honor, the legislature, in adopting a statute and framing the scope of review under Chapter 40, Section 23, addressed just this situation. And by comparison, this is a different standard than Chapter 48, Section 17, where the legislature says the court is to determine whether the zoning board exceeded its authority. Or under 41, Section 81BB for subdivision approvals, the certiorari application to conservation commissions. Here the legislature said that in the event of an approval with conditions, that the decision shall be reviewed to determine whether those conditions render the project uneconomic and whether those conditions are consistent with local needs.
Well, the Attorney General takes the position that reducing a product is the number of units is not a condition within the meaning of the statute. So let's, and I'm not sure what to do with that, but
Your Honor, I'd be happy to address that.
But you mean the Housing Appeals couldn't say that certain reductions are in effect denials, which they have said here, and that we will then consider those as denials in excess of the units actually approved, so that we use the denial standard to look at this as opposed to the condition standard.
Well, Your Honor, I suggest in response to your question, the Housing Appeals Committee is doing the same thing through the back door that it accuses zoning boards of doing. The Housing Appeals Committee is accusing zoning boards of saying you're actually denying when you impose a condition on the density, the number of units. When in fact the Housing Appeals Committee, rather than addressing the statutory framework for judicial review, whether the project is rendered uneconomic by the conditions, the Housing Appeals Committee is flipping the decision, turning it to a denial, then changing the burdens of proof under both the statute and the regulations. And frankly, the statute is very clear, and as well the regulations are very clear, specifically density. We've cited in our brief to the fact that under the regulations, an applicant for a comprehensive permit has to submit an application, and this is preliminary design. It's not full construction drawings. The preliminary design and the application has to include, pursuant to 760.31 1.20, subsection H, a list of requested exceptions. It's incumbent upon the applicant to inventory the local approvals, zoning bylaws, general bylaws, rules and regulations, local wetlands regulations, inventory those and determine how this project needs relief from those particular regulations. It's required as part of the application. And I suggest in response to your question, Justice Cordy, that in proposing a project, an applicant has to say, this is an R1 district that only allows single-family homes, 107 single-family homes as a matter of right, 225 townhouse apartments by special permit. We want to put 640 units on the 74.5 acres on this site. So we need relief from the use restrictions, the density restrictions. The record indicates we raised this issue before the Housing Appeals Committee. The applicant never specified the type of zoning relief it needed for the density and the types of buildings it was proposing.
Does the town or does the city have a planned unit development regulation that permits cluster zoning? For subdivisions.
I believe it does, Your Honor. Sort of an open space development, which would allow the clustering of units to preserve open space.
Yeah.
I believe it does. Woburn, as you know, is a heavily populated community. There's certain areas of open space to that extent, but I couldn't specifically tell you how that applies here, Your Honor. Here, there's no question, the zoning was R1. The applicant's proposed density was 6 times the allowable density for single-family homes, 3 times the allowable density for townhouse units. The city zoning board approved this at 300 units, which was 75 above what would have been allowed by special permit. And therefore, 25% or 75 units could have been affordable back in the year 2001 when this decision was approved, understanding the court's concern with the expeditious requirements of 40B. The applicant chose not to accept the 300 units and proceeded to the Housing Appeals Committee.
Mr. Brackett, if Woburn had said, which in substance it did say, we think that 640 units is not consistent with local needs. We're just denying the project. We're not going to tell you that, we're not approving it with conditions, we're just denying it. It would go to the Housing Appeals Committee, which has said also 640 isn't consistent, but would the Housing Appeals Committee be able, under that denial standard, then be in a position to say 640 isn't, but 520 or, pick another number,
540?
It would not, Your Honor. Under the specific regulations which are attached as appendices, pages 110, 111, and 118, which govern burdens of proof, scope of the hearing, decision, and appeal. The Housing Appeals Committee is required in the case of a denial to determine whether or not the denial is consistent with local needs. If the Housing Appeals Committee overturns the Zoning Board of Appeals, the matter would have to be sent back to the Zoning Board of Appeals for a decision not inconsistent with its ruling. However, in this case, both the Housing Appeals Committee and the Superior Court, in accepting and affirming the committee's decision, determined that 640 units on the 75-acre parcel was too large a project on busy Cambridge Street.
Yeah, that's what I'm asking. So would they just be bound by that? In other
Yes.
words, if they found, then there would be no project? Is that what you're saying?
That's correct. The applicant, certainly with that, there would be nothing to prohibit the applicant from submitting a new application to the zoning board with that guidance. 640, the zoning board said it's too high. The Housing Appeals Committee said that's too high a density. Take a look at the application of the zoning, the R1 district. We thought it was very interesting.
Is it your position that the imposition, an approval with the imposition of conditions is a denial?
No, it is not, Your Honor. Clearly is not.
That's somebody's position in
It's
this
the-
case.
Yes.
It's the Housing
That
Appeals
can't
Committee.
be right, can it?
It cannot, Your Honor, because frankly, Your Honor, we have cited to the fact that the Housing Appeals Committee some years back in the Cooperative Alliance versus Taunton decision, a 1992 decision by the committee, set out a set of various categories of the types of decisions that might be presented. Where conditions are presented that do not render the project economic, what is the Housing Appeals Committee role? And there it says, in 1992, if the condition doesn't make the project uneconomic, the developer has not sustained its burden of proof.
Right.
No
Mr. Black-
further inquiry into the consistency with local needs standard is
Mr.
necessary.
Blackett,
What's the
let me-
site?
I'm sorry.
This is Cooperative Alliance versus Taunton, 1992, HAC decision, which we have cited in our brief.
Mr. Blackett, let me ask you this, and this is what I think this is what's unusual about this. There's a proposal for a 640-unit development, right?
That's correct, Your Honor.
Which the town rejects as inconsistent with local needs. But the town, in essence, says, we think a project of 300 units is consistent with local needs, correct?
Not only consistent with local needs,
Well,
Your Honor,
they're just saying 300 will
300
meet,
units.
and we will give you a permit.
the zoning board was prepared to issue that permit in
No,
2000.
I understand that. I understand that. I'm going to a more fundamental question. But the developer hasn't accepted the 300, correct?
That's correct, Your Honor.
What is the jurisdiction of the Housing Appeals Committee at that time? In other words, it seems to me that one reading of the statute, it may not be the most economic, may not make the most sense, is to say that there's a rejection of the 640. There's a kind of counteroffer from the town which the developer can accept or refuse, can do that under Booth Lloyd. the developer doesn't want to accept it. And so the only thing that is before the Housing Appeals Committee is the denial of the 640. Because there's no project on the table for 300 units. Why would that not be a correct reading of how the statute is supposed to work?
Well, Your
Because
Honor,
that goes to Justice Botsford's question,
well, Your
which
Honor,
is if that was the denial, then the Housing Appeals Committee, could not come in and say, do 540.
clearly, if it's considered that the decision denying it 640 is consistent with local needs, the Housing Appeals Committee has no authority to substitute its proposed number to the zoning board. The Housing Appeals Committee could suggest that the matter be remanded back to the zoning board for a new application and further consideration of a new application within the framework of that decision.
In other words, why don't we ask developers to say if the developer can accept? I came in with 640, and I think it is consistent with local needs, so I'm going to take that up to the Housing Appeals Committee. No problem there, they can do that. Or I have to submit another proposal, and the proposal might be 300, which is what the town says it'll grant. The developer doesn't want that, so the developer looks for a number between 300 and 640 and comes up with a number of 522, takes that to the town, and the town says inconsistent with local needs. That goes up to the Housing Appeals Committee, and the Housing Appeals Committee says, no, that is consistent with local needs. Permit granted. Isn't that a better way to go about it?
Your Honor, I understand that that may be an alternate way to go about it under these circumstances, but we're faced with the circumstances of this case.
No, I understand
which
that.
involve the fact, Your Honor, that when the Housing Appeals Committee first determined in 2003 that the applicant failed to sustain its burden, the Housing Appeals Committee in its decision says, normally our inquiry would end here.
Correct.
The Housing Appeals Committee acknowledges that it should have ended it. The matter of the burden of proof had not been established to the satisfaction, and the Housing Appeals Committee and the Superior Court decision indicate how there were failures in the cost estimator, the project manager, the real estate consultant. Their testimony did not support the argument that the project was uneconomic at 300 units. And for the court's information, during the course of the Housing Appeals Committee hearing, it was established that the purchase price for the property would range from $18 million at a low for a minimum of 320 units to $34 million at a high for a maximum of 640 units. So the purchase and sale agreement between Archstone and Northeastern anticipated the possibility of a range of density between 320 and 640. The importance of our argument with respect to the error of the Housing Appeals Committee, the Housing Appeals Committee should have ended its inquiry at that point, once determining that the economic burden had not been established. Rather, it then decided to evaluate it under a burden of proof pursuant to its own regulations, which does not shift to the board, the zoning board, unless the applicant proves the project is uneconomic. But the Housing Appeals Committee decided to go forward, evaluate all the conditions, change the conditions, and frankly, members of the court, having participated in the 9 months of hearings before the zoning board and the 27 days of hearing before Attorney Lawrence Stiller-Rickling as hearing officer, the Housing Appeals Committee's sole basis for 420 was the purchase and sale agreement between Northeastern University and Archstone. Our argument was that that was actually more arbitrary than the allegation that 300 units was somehow or other an arbitrary reduction from 640. We argued before the Superior Court that this exceeded the scope of the Housing Appeals Committee review, and the situation only got worse. The Superior Court judge said that the Housing Appeals Committee should have treated this as a denial. Well, members of the court, frankly, the Superior Court did not have the authority to do that, to dictate that. Under a 3814 standard of review, the Superior Court was required to determine whether or not, under 3814, whether the Housing Appeals Committee had committed errors of law.
Didn't the Housing Appeals Committee also say it was treating it as a denial?
No,
Not
the
at
Housing
first.
Appeals Committee,
Not at first.
not
Okay.
at first.
Okay.
The Housing Appeals Committee, and the court acknowledges, and we've cited in our brief, the court acknowledges that it was treating it as an approval with conditions. The opponents have argued that the court should accept the Settlers Landing standard. I would suggest to you, number one, that Settlers Landing should not apply here. The Housing Appeals Committee made it clear that the standard there, as a matter of fairness, would be that the decision as to what the burden of proof would have to be announced at the beginning of the hearing in order to allow for a fair and equitable hearing. Through 27 days of hearings, the burden was on the applicant to prove the project was rendered uneconomic, and only then would the burden have shifted to the zoning board to establish that the decision was inconsistent with local needs. And under the circumstances, the Superior Court ignored that standard. And I'll just briefly, understand my time is up, I'd just briefly like to address the issue with respect to the remand.
Mr. Blackett, your time is up. So we'll read the argument in your brief.
Thank you very much.
Thank you. Mr. Wilson?
May it please the court, Paul Wilson representing, along with Brian Blazer and Ben Timon, Archstone Smith Operating Trust, the developer which has been trying for 7.5 years now to construct this particular affordable housing development in the city of Woburn. At the heart of Mr. Brackett's argument is the notion that the Superior Court and the Housing Appeals Committee created a third category of decisions, a de facto denial. In fact, what happened was that the Superior Court and then the Housing Appeals Committee looked at what had been put by the Zoning Board of Appeals in one of the categories recognized by the statute, an approval with conditions, and said that based on its substance, it was really properly put in the other category recognized by the statute. It was a denial.
So we're prepared, let's say we're prepared to accept that, all right? It's
Yes.
a denial
All right?
of a 640-unit development, properly denied.
Right.
So, end of story.
Yeah.
Well, first of all, that argument appears for the first time in Mr. Brackett's
No, but I'm just
reply
taking it as
brief.
a point of statutory requirement, right? I mean, how can the Housing Appeals Committee, if it's a denial, I understand they didn't, the Housing Appeals Committee may have been correct the first go-around, right? Maybe the Superior Court wasn't correct, but if it is a denial, what's the basis for the Housing Appeals Committee then to say do 540?
Well, the Housing Appeals Committee explained that in an earlier decision called
Right.
CMA versus Westboro in the early 90s, where it said it faced this very
Right.
situation. It saw a denial. It saw a denial of a 180-unit development as not consistent with local needs, so it reversed it, and then was faced with a 180-unit development that it said was inconsistent with local needs, too big, because there was not enough recreation space, because there was a logical connection to real health and safety problems. And the committee said in its decision, we are now faced with the possibility of saying no, because it's slightly too big, to a development which would produce much needed affordable housing. And we are going to do what the statute, we're going to follow the statutory intent here of creating the housing by knocking one of those buildings out, reducing it in size.
Where in the statute is that permitted? I can't find that anywhere.
In the consistent with local, if the decision is a denial, the question is it consistent with local needs?
Right. Is the project as proposed consistent with local needs?
But here, we had a 27-day hearing brought on by the insistence of the ZBA that this was something else. It was actually an approval with conditions. And if you're interested in applying the statute in a manner that would result in expedition, to have wasted that 27-day hearing would not
Oh, I
be...
mean, the developer can always go back. Housing Appeals Committee could say, no, the denial, this project was too big, the town properly denied it. But it seems to us that a project of 150 units, talking about this 180, would be consistent. And the developer then can go back and presumably present a project with 150 units. And if the town denies that, then chances are the Housing Appeals Committee is just going to overrule that.
In fact, the developer can do something else. He can, under the regulations of the Housing Appeals Committee, he can actually, in the middle of the Housing Appeals Committee hearing, if he sees that the wind is blowing the wrong way, he can propose a smaller project at that point. And that sometimes does happen. It does not need to get remanded because it's a reduction of the impacts because of the reduction of the units, and that can happen too. And that's, in essence, I think, what happened here. Sorry, Your Honor.
You see, what is the town's 300, I mean, what's the status of the town's 300 units? And it seemed to me that the Housing Appeals Committee focused on what the problem was. It said, there's ample evidence to support the board's position that 640-unit proposed development is too large. Bang, okay. Nonetheless, the committee remains confounded in trying to discern the board's basis for limiting the development to 300 units. I don't know what the basis was for limiting it to 300 units. In other words, it was, I mean...
The Settlers Landing test, developed in a case that came out 3 months after the first Housing Appeals Committee decision here, gives the answer to that question, Your Honor. It says that there has to be a logical connection between the reduction in units and an actual health, safety, environmental planning type, open space type problem specified in the statute.
And
Here, there was none.
if there isn't, what? Then it's a denial.
And if there isn't, then it's a denial. That's
And
right,
it should
Your
be
Honor.
treated as a denial.
That's right. That's right.
But not a denial of some hypothetical project, a denial of the actual project
Right. The
proposed.
300 unit was an entirely hypothetical project. It was a number, as the excerpt you just read, Your Honor, indicates, that was apparently pulled out of thin air.
Well, it says generally, and then I understand about the CMA, the Westboro case, but generally, the nature of the appeal process is such that the committee will either uphold the reduction in units or approve the original plan at the size proposed by the developer.
That's right. And in the first decision here, the Housing Appeals Committee was very careful to say we do not often exercise our power to go beyond saying we affirm a denial. But we have the power to do that because it's inconsistent with the legislative intent, the statutory mandate of avoiding municipal manipulation to permit a town to do what this town did here, to try to send a message not only to this developer but to other developers, don't come to our town because we, the town, are going to choose the number of units. You, the developer, are not.
Would it be fair to say that...
But the developer chose 640.
The developer did
And that
choose
was
that
not
number.
consistent with local. So the developer made its choice.
And in a two-part hearing here, the developer did what the regulations would have permitted in a one-part hearing. That is, it came back with a lower number, and then the Housing Appeals Committee considered, is this change proposed by the developer now, does that insubstantial change, reduction in numbers, make the project consistent with local needs?
Are you
And the
saying the
answer at that number
developer-
is yes.
You're saying in this case, the developer came back with that lower number?
At the second hearing, that's what second of the two Housing Appeals Committee hearings.
Not in the first, right?
Not in the first, but
And
it-
who took the appeal to the Superior Court?
pardon me?
Who took the appeal to the Superior Court?
Both sides
the
appealed
first
from
time.
the first. Both sides appealed from the first decision.
And what was your client's argument there? Was it for 600? Was it for its original 640, or was its argument that the 420 that the Housing Appeals Committee had extracted from the PNS, you know, that originally had the link to 420? What was your client?
That was my client's argument at that point. That
That the
there was
420
no basis for the 420. The Housing Appeals Committee had made the same error, that is, that the ZBA had made. It had picked a number without sufficient support.
Was it? Did your client challenge that the 640 was too large, imposing significant burdens?
In the Superior Court, that wasn't the focus of the argument. I don't know if the focus of the argument was whether this had been properly treated as a denial or a condition approval with conditions, and whether the 420 was right. I don't recall if in the notice of appeal, if it went as far as just to say, please uphold the 640. I just don't know that information.
Mr. Clay, I'm not using up your time. Don't worry. Mr. Wilson, why was it not possible or did the Housing Appeals Committee attempt to take an appeal from the Superior Court's order? Am I missing something here?
The Housing Appeals Committee did not appeal from the Superior Court's order in the Superior Court's first decision in this case. So I'm not sure if that answers your question.
Because my question is, if the Housing Appeals Committee acted in a way that it thought it had the authority to do it, and the Superior Court is saying, yes, you have the authority to do that, but there's not a sufficient basis in the evidence for you to pick 420.
Right.
Then I suppose and I'll ask Mr. Clay this, then I suppose the Housing Appeals Committee is put between a rock and a hard place. Namely, they've got the authority and there's a kind of factual problem about whether 420 is supported or not supported.
I think it's fair to say that the Housing Appeals Committee saw job at that point as to accept the remand from the Superior Court to revisit the issue of whether 420 was the right number, to do what it could have done if the developer had asked at any point in the first hearing for 540 or any other number of units.
It's a little odd because if the Housing Appeals Committee is going to exercise this discretion, and you've essentially got the town saying 300 and the developer saying 620, it strikes me that there would not be a vast amount of evidence in the record that supported 420 versus 430 versus 440. In other words, on what's going to be the basis of the Housing Appeals Committee?
That's exactly right. That's the touchstone, Your Honor. What is in the record that supports the ultimate number? And if there is a record that says 640 is okay, as there was not here, fine, 640 gets approved. If that same record shows that 540 units is okay, then the Housing Appeals Committee can do that. There was nothing in this record that supported or even explained the 300 units, however.
What about the 420?
With the 420, there was evidence which the Superior Court found, I think appropriately, to be unsupported by substantial evidence, because the Housing Appeals Committee made a mistake by forgetting that the 420-unit number it was taking out of a purchase and sale agreement was in a purchase and sale agreement that was premised entirely on an entirely market rate, unsubsidized development, and more units would be necessary to have the equivalent.
But the question here is, I mean, the point that I'm driving at, and perhaps not in a very articulate way, is that the developer is not coming in saying, the developer is coming in arguing in favor of its 620 units, correct?
Originally, yes.
Yes. And the Housing Appeals Committee now says, well, we have the authority, jurisdiction basis, statutory authority, whatever it is, to reduce that number. But it seems that there would, in most cases, not be a lot of evidence about any number between 300 and 620. In other words, it's easy to get rid of the 300.
No, I disagree, Your Honor. I think, for instance, if one building with 50 units had been built in a wetland, that would have become obvious in the record.
But we're not talking about that. We're talking density. We're just talking density here.
But there is no ability of anyone, of the ZBA certainly, to say this is too much density. That only matters if the density, if there's a logical connection between the units being stricken and some health safety planning issue. Okay. And here you can often have a case where the Housing Appeals Committee is in a position to say this is too big a development, but I see what a smaller one would be acceptable at this size.
Surely what it should have done at that, well, okay.
So what was the evidence that supported a project of the size 420?
Just that the purchase and sale agreement between the seller and Archstone Smith had in it the notion that had picked 420 as a sort of a neutral number. The payment would be based on 420 units, except in certain circumstances.
So what's the difference between what the Housing Approval Committee did and what the town did?
Oh, what the Housing Appeals Committee did was it got to 540 by looking at balloon tests of how tall the buildings were, would they be visible.
In the
second go-round, that's right.
Then
yes.
Who challenged that decision back up to the Superior Court?
That only the ZBA challenged that decision back up to the Superior Court and eventually here.
And who proffered the testimony about what the appropriate size would be?
Only the developer. On remand, Judge Muse instructed the Housing Appeals Committee to consider what the right number was and said that it could hear new evidence if it wanted. Archstone chose to present new evidence, and the town chose not to present
Okay, and Archstone at that point presented evidence that is. Did it decide that 540 was the number and
Yes.
it was going to give evidence?
Alternative plans, how the height would not be visible, what the traffic impact would not be. That's sort of the basic evidence of a Housing Appeals Committee proceeding. And the town chose only to cross-examine, essentially.
Couldn't the judge, or maybe shouldn't the judge have, if there's no basis for the 420, have remanded it back to the ZBA to do exactly what happened in the Housing Appeals Committee?
Well, at that point, we were 5 years into a proceeding, and as you know, expedition is supposed to be one of the goals of this statute. And to go back to what I think the Superior Court, certainly saw, and the Superior Court may have seen as an offending ZBA, which had picked a number out of thin air and said that's all you can have, would have just resulted in further delay, and we would have ended up going through the same process anyway.
Thank you, Mr. Wilson.
Thank you, Your Honor.
Mr. Clay.
Please, the Court, Pierce Gray, Assistant Attorney General for the Housing Appeals Committee. Let me start with what's been the focus of Your Honor's questions to Mr. Wilson, which I take it to be, if one were to assume for the sake of argument there had been a denial here, what was the committee's ability to go down given its finding that 640 was too big?
Right.
Let me advance two rationales for that. They're not in our papers because, again, this issue only emerged in the reply brief. The two rationales I would point to, if you look to Section 23, it talks about whether a decision of the Board of Appeals is consistent with local needs. Our view, and again, the committee has recognized its ability to go down and what it views as its ability to go down in prior decisions, as Mr. Wilson indicated. But one basis for that is that if a board comes in with denying a number, where it can be readily, the issue about it being too big can be readily addressed by going down, and the board chooses not to.
Or the developer has chosen not to. What do you mean the board has chosen not to?
So the board simply, it was an amount that could be there, it could go down, that the committee should have the authority to view that decision writ large, not just denying the 640, but also not being willing to consider lower, as itself not consistent with local needs.
But whose
But they did
responsibility is
consider
this?
Pardon?
Isn't this the developer's responsibility to sort of size the project?
Well, the developer's arguing that the project is just a fine size, thank you very much. In other words, the developer's saying, no, I want to go to 620. So it's kind of hard for the developer to say 640. 640 is what I want. 640 is consistent with local needs. But
They lose.
No.
And they lose on 640. So what you're saying is, yes, the board was perfectly correct in denying the permit for 640. And in fact, we would say, yes, it should have been denied, but we have a better plan. We're not going to send this back to the board to sort of consider whether a smaller plan would work or whether the developer is even prepared to present a smaller plan. We're just going to, on our own, decide.
Where I differ, Your Honor, is the board isn't necessarily correct at denying at 640 if the problem easily could have been remedied by going down. Rather than sending everything back to the drawing board, it would effectuate the statute's purpose of not just increasing the supply of affordable housing, but expediting it
So
for
if
the
the board does reduce the number, is that a condition or a denial?
Our view certainly is that, at least to the extent the settler's landing standard is satisfied, that would be a denial. Indeed, two Superior Court judges have said that any reduction
This is very
Mr.
confusing.
Cray, you treat a denial when the board has said, we don't want 640, but we'll take 300. That's a denial. But I thought you were just saying, if the board had just said, we're not taking 640, denied, you would say the Housing Appeals Committee, when it gets up to you, can say, oh, that could easily be fixed, so we're going to pick a number?
Yes, Your Honor. That has historically been the practice. I don't believe the developer challenged that, its authority to do that here.
Ray,
Yes, Your Honor.
can I suggest a simpler analysis, and maybe I'm wrong? If we reject the argument that what occurred here was, quote, a denial, which personally I think we should, because that could lead to all kinds of problems with all kinds of other conditions, we then get into the second part of the statute, which is conditions. This is a condition, 300 units. Did the developer prove that uneconomic?
No, to the
No.
contrary.
No, it did
That's
not.
correct, Your Honor. And I actually, Your Honor, would I'm sorry, Your Honor.
Well, no, go ahead.
I would actually disagree that it should be treated as a condition, because if one looks at the definition of uneconomic in Section 20 of the statute, it really says, what it says is that it looks as to whether a condition, what it calls a condition, makes it impossible to realize a reasonable return, and then it says, within the limitations set by the subsidizing agency on the size or character of the development. In other words, major project parameters, like the size of the development, are meant to be held constant, and then you evaluate whether or not a condition, what's the fiscal impact of a condition is, given those.
Well, isn't it the
fixed
case
parameters.
that you don't want it to be treated as a condition because in fact the developer was unable to establish that it's uneconomic? I mean, that's the standard for a condition, right? And
If it's a condition as opposed to a denial.
that's why you don't want it to be a condition, because you lose. So
Right,
you
and
want
we're
it to
saying-
be a denial, and you want to create a different standard because there's a different standard for a denial.
But, Your Honor, we're saying that if you look at even the definition of uneconomic itself, it doesn't contemplate the size of the development as being the type of thing that you analyze under that. It instead accepts that as a fixed parameter that it should be, that you evaluate other design details about. For example, also, if you look to Section 21 of the statute, where it talks about conditions, it uses language that bespeaks how the project should be developed: height, building materials, not something as
Size.
fundamental.
But how could size not be the key issue on whether something is or isn't uneconomic?
I would submit, Your Honor, the legislature already assumed that if you reduce something, it's per se, you move to just looking at whether it's consistent with local needs.
But your whole decision is based on they hadn't proved it wasn't uneconomic.
Yes, and Your Honor, and we conceded subsequent in the litigation, after the settlers' landers standing was issued, and after reviewing the Superior Court's decision here and some of the other Superior Court cases that have been quoted in the briefs, that was wrong, that it should have been treated as a de facto denial from the outset.
If it isn't, you're stuck. If it's an approval with conditions, you're stuck.
Unless we accept your uneconomic, that a
No.
reduction in size is...
We don't say we're stuck. In answer to your Honor's, Justice Graney's question, we don't say we're stuck. There's an additional issue that's briefed extensively by Mr. Wilson in his brief that we adopt by reference as to why there still would be the authority to address conditions, even if, in certain circumstances, even if uneconomic is not proven. Let me just return to our second rationale for why, if you assume a denial is found here, the committee had the authority to go down. The board's Hanover case, which was the initial major decision here, has references at pages 354 and 364 to 65 that we would have traditionally been taken as establishing a general parity in what boards can do and what the committee can do. There it was saying the board has the same power as the committee. We think it's reasonable. You could also say the committee should have the same power as the board within that. There's no dispute that a board can reduce the number of units if that specific reduction is consistent with local needs. We think correlatively the committee should have the same power. And I would close by noting that the court has said in the past repeatedly 40B is a reform statute. It's meant to be construed broadly to effectuate the purposes of that reform. And then indeed, in the court's language is, if a liberal, even if not literal, reading of some of the words of the statute would further that, that should be done here. The net result, if Mr. Brackett's position is accepted, is that there will be a green light to developers to always downsize developments down to the uneconomic level plus one more, basically what the briefs refer to as uneconomic plus one. That's a green light to reducing the amount of affordable housing that would otherwise be built.
Well, that's not the case, actually, because if the Housing Appeals Committee concludes that the rejection of the project as proposed is inconsistent with local needs, then they get to decide. Then the Housing Appeals Committee basically wears the hat of the board, and it can decide and approve a lower any project it wants, right?
Yes, I was saying if one accepts all of Mr. Brackett's arguments, I believe Mr. Brackett was contesting what Your Honor just characterized as the committee's powers.
The predicate is that, I mean, never mind. That's all right.
So that was
Your
to be
time
the
is
net result, and I appreciate your time, Your Honor.
Thank you, Mr. Clay.
All rise.